Welcome back to the show. As you can see on the screen with me is someone you haven't seen with the Sean Burke Show before, but you've heard his voice quite a bit. This is Professor Rob Natelson, one of the favorites. We have a fan favorite back today. Welcome to the show again, Rob. Nice to see you actually on camera.
It's great to be back with one of the most thoughtful shows in America.
Thanks, Rob. Rob is, I won't list all the incredible things that he is, but he's been a law professor for a couple of decades in Montana. He also ran for governor in Montana and placed second out of 5 and did a good job there. He also is with the Article 5, the Independence Institute's Article 5 Information Center. He heads that up. He works with the Independence Institute, but the Article 5 Information Center is the center that talks about how we could potentially amend the Constitution. We've had a story on that. We've done a number of shows with Rob. I always like to mention he's fluent in Latin because that just intimidates the hell out of me. And he has been off a little bit, and I haven't been able to get him on the show, and he's back, and I'm very happy to have him. Today, our topic is going to be the constitutionality of President Trump going forward and nominating Amy Coney Barrett to the Supreme Court, and not only the constitutionality, possibly looking at wasn't it his job, and also the Senate's job. Should they stop just because it's an election? We're almost at the election. So that's and this is the man who has the originalist. He is an expert in originalist understanding of the Constitution. In fact, the Supreme Court has used some of his and cited some of his work, which is one of the highest things that anyone in that profession can say. It's very impressive that Supreme Court has used his work as well. So, all right, Rob, so let's dive into it. We have Donald Trump. The election is less than 2 weeks away now, I think. Justice Ginsburg passed away. There was an opening. Should he have not have nominated someone? What's the Constitution say?
Well, it's controversial, but the constitutional issue was originally raised by Joe Biden. Joe Biden served in the Senate, as you know, for 30 some odd years, served as vice president for 8 years. For 8 of the years he was in the Senate, he headed the Senate Judiciary Committee, which focuses on legal and constitutional issues. He's also a lawyer. And so when he argued that the process of nominating and potentially approving Judge Barrett so close to the election was, quote, not constitutional, that got a lot of eyebrows raised. Around the same time, Senator Patrick Leahy, a Democrat of Vermont, said that the process was illegitimate, and that's been picked up in several other Democratic sources. Senator Leahy served in the Senate even longer than Joe Biden did. He served as chairman of the Judiciary Committee even longer than Joe Biden did, and he's also a lawyer.
Okay.
So this is pretty good authority, right?
We have these supposedly knowledgeable guys throwing down the unconstitutionality card.
Yeah, so let's a third example. Russ Feingold, famously former member of the U.S. Senate, another lawyer, now heads a group called the American Constitution Society, which is kind of the liberal answer to the Federalist Society, if you know what that means. It's an organization of liberal law professors and students and lawyers. And he's issued a whole series of letters or emails in which he says this nomination is illegitimate and an attempt to steal the Supreme Court's seat. So these are pretty serious charges by guys who should know what they're talking about. Unfortunately, Sean, they don't know what they're talking about.
Well, hence why I turned to Rob, my friend Rob Natelson to clear it up.
And even CNN rated Biden's charges false.
Wow, well, that's saying something. CNN did it. That's saying something there.
Now, here's what here's the constitutional background. The president's job description is listed in the Constitution. It's mostly in Article 2 of the Constitution, not exclusively, but it's mostly there. And it says that he shall nominate, and with advice of and consent of the Senate, appoint judges of the Supreme Court. They use the word judges rather than justices. Now, that little clause serves two purposes. It gives the president the power to nominate, but because it says shall nominate, it's a form of speech we call the future imperative, common in the Constitution. He must nominate. This is not something he cannot do, okay? Then another part of Article 2 also.
So shall is key there. Shall is a key word in that.
It's key. It's not may, it's shall.
Yeah. All right.
Then in addition, there is there's a provision which says, also in Article 2, that the president shall serve a term of 4 years, right? Now this is a fixed term, and we think of it as kind of natural, but actually it was not natural at the founding era. They were very familiar with other governments which had executives that served indefinite terms. So like the King of England, for example, they might serve for life. You never know when he's going to die, right?
Yeah.
Or like the prime minister, who shared the executive power, they would serve at the pleasure of parliament, or as long as they could hold a majority. So many republics and kingdoms had this uncertain term for the chief executive. The founders decided, no, we want a fixed term. And that wasn't unprecedented, but they said, we want a fixed term. So the president is reasonably independent of the legislature, and he's also independent of outside events, like, for example, elections, right? Mm-hmm. So even when the election is going on, it's not like in a parliamentary country where you call an election, everything comes to a screeching halt. He is supposed to continue with his duties during the election. And here's a good analogy that illustrates the point. The Constitution has another little phrase in the future imperative that says the president shall take care that the laws be faithfully executed. You can imagine the outrage if President Trump said, well, you know, there's an election coming up and there are some other controversial laws out there and I'm not going to enforce them during the election season. Mm-hmm. That's sort of comparable to what it would be if he's refusing to nominate Supreme Court justice. The next little piece of evidence comes to the Senate's role. The Senate must advise and consent. That is to take under consideration and either consent or turn the nomination down. But really, they've got to act in some reasonable amount of time. They don't have to hold hearings. I mean, that's where the Democrats were wrong about Merrick Garland. There's no constitutional requirement they hold hearings. Their procedures are totally up to the Senate. But they can't simply ignore their duties because an election is coming. They also are elected for fixed terms, right? For 6-year terms. They've got that responsibility right away, all through that period of time. And then finally, I'll end this very long answer with a point that there is also a provision of federal law. It's 28 U.S.C. United States Code, Section 1. It's passed by Congress. And it says that the Supreme Court shall consist of a Chief Justice and 8 Associate Justices. Right now, the Supreme Court has 7 Associate Justices. Now, it's legitimate for it to meet because its minimum quorum is 6. But the clear effect of federal law is to send a message, you know, it's got to be 9. And if there is a vacancy there, it's got to be filled as soon as reasonably possible. So in summary here, the idea that there's something illegitimate or unconstitutional or a steal about the president carrying out the duties for which he was elected and the Senate carrying out its duties, it's simply wrong to claim that.
Well, it's certainly politically motivated to claim that. Of course, here we are I mean, and they can say what they want. Throw around Sean, that it's unconstitutional is a different deal.
But what bothers me, you know, I mean, it's absolutely legitimate to say something like, gee, can't we just wait 2 weeks, or this is not a good time, so long as they're not talking about too long a period of time. January is too long a period of time. But for people who really should know better, to say that this is unconstitutional or illegitimate suggests something very seriously wrong.
Interesting. So the other thing I think we need to look at is the president's term whether if he loses even, doesn't end until January, what,
That's right.
20th?
20th.
20th. So he's actually has a duty to fulfill his role. If he loses on November 3rd or whatever date we actually learn if he loses, he has to continue being the president even up to January 20th. So it's not like we do an election on Tuesday, November 3rd, and then he loses and he's out of office on the 5th, and he's got another couple months
Yeah,
minimally to go.
it's
So
not.
this
It's
it,
not a parliamentary system.
no, and we're not close. I mean, really, 2 months more of his job. Now, does the senators also get sworn in? I don't know when that swearing is for senators.
The
What
3rd
is?
of January.
Okay, so they
3rd of
even if they lose, they still have a couple of months in office. So really, we have when Justice Ginsburg passed away, easily 3 or more months before there's any transition of power
Mhm.
in the country. So it's a little, people, especially out here, us folks that are not really tied into all that, think, oh my gosh, there's election, we should just wait a week or two. But it's actually not. It's months down the road. And
Yeah.
we just had the Supreme Court passed down a judgment the other day, a couple of days ago, that was tied. It had 4-4. So that's what
Mhm.
happens when you have not enough justices on the Supreme Court, is you don't have an actual decision that can go forward with some kind of majority.
Yeah, that's exactly right. In 1800, John Adams was defeated for reelection in a sweeping victory for the Democratic Republican ticket of Jefferson and Burr. At that time, the president served until March after the election, and there was a vacancy on the Supreme Court, a very important one, the Chief Justice.
Hmm.
And so John Adams, as a lame duck, not before the election, but after the election, as a lame duck, tapped his Secretary of State, John Marshall, to serve as Chief Justice. And John Marshall went on to become the greatest Chief Justice the Supreme Court has ever seen.
Interesting. So, I mean, you could even that's an interesting scenario. So, let's say President Trump loses, another justice pass away. He could literally, again, until January 20th, he fulfills that role in that position. I
That's
hadn't
right.
thought of that. That's fascinating. Um, okay, so let's look back a little bit at when the Constitution was formed, sitting in that room, in Independence Hall in Philadelphia in 1787, and they're looking at these kind of things.
Mhm.
Little did they have the knowledge that today we would have campaigning for president running a year and a half or 2 years ahead of when the actual election is. Back in those days, the candidate didn't really campaign. Of course, President George Washington didn't do anything. He basically was asked to go in and do it. And then it got more and more as we went on. But if you think in their mindset, um, they're thinking, well, good, there's going to be an election, but this guy has to keep doing his job until he's out of office. So it just, when I think of the pragmatism of these people who are putting this Constitution together, they would, I would think, absolutely expect that the chief of the country would do his job if there's a vacancy somewhere.
Yeah. By the way, the I wanted to just push back a little bit on the statement you made. I
Good.
think it reflects a common view that the founders did not anticipate party politics. Very common view. Um, that they did not anticipate the party politics. They thought of the president as sort of, he'd be kind of above politics. They really weren't that naive. Okay, some of them hoped that might be the case, but they saw party politics and they knew what it was like to campaign. George Washington, the first time he ever ran for the House of Burgesses in Virginia, um, thought he was going to win on his platform and did not provide adequate booze for all the electors who came together to vote. And he was defeated. The next time he provided lots of booze
More
and he
booze.
was elected. I mean, that was a way of campaigning in those days.
Yeah.
There was often a show of reticence, of not campaigning, and occasionally it was real. But But there was a great deal of campaigning. And of course, it had already begun really in Washington's second term when two members of his cabinet, that is to say, Hamilton and Jefferson, were at each other's throats.
Yeah, I know that Washington and especially and also Adams were very reticent about what was coming with the split in the country as
Yeah.
far as parties go. In my book, I have a few of those quotes, so studied that a bit. So, Rob, this brings up to me as I was thinking of our conversation. So, there's the originalist theory, the theory that we keep the words, we I'm butchering this, but you follow the Constitution based on what's written and what
Mm.
the intent was, and then you have a revisionist theory. Why not? I'm all for let's go with what it's actually written. It's been successful so far, but why not change it? Why not go on a new thing? Why not, hey, wait a second, it says that about the president, but now things are different. We should make it so that he couldn't nominate Judge Barrett. Why
Well, we
stick
could
to
do
that
that. Well,
originalist
we could do that, and there's a proceeding for doing that. And it's called the amendment process. The problem with changing the Constitution, other than the amendment process, is it's usually done behind closed doors, generally by the Supreme Court, by 5 justices on the Supreme Court. But there's a wider answer to it as well. Originalism is nothing unusual. I mean, it is what originalism is interpreting the Constitution according to the meaning of the people who approved it. That was to say, the elected ratifying delegates. Sean, that's the way we interpret virtually all legal documents. We interpret statutes by its meaning to the legislators who adopted it, not by the meaning of the folks in the office who drafted it, but by its meaning to the legislators. If somebody makes a will and then dies, we interpret the will according to the intention of the person who made it, the testator. If we have a contract, we interpret that contract according to what the bargain of the parties was. If we don't know exactly what the bargain of the parties was on a particular point, then we have to say, well, what would it mean to a reasonable person in the normal course of events? This is called original meaning. What would it mean to the normal person in the original course of events? And in the absence of evidence to the contrary, we adopt that meaning. So this is what we do with almost all documents. And it's been true, with the partial exception of real estate conveyances, it's been true in Anglo-American law for at least 500 years. The founders knew this. The great guru of interpretation in the founding era was a man who had been dead for well over 100 years, named Salkeld, William Salkeld. And we have a letter in which John Dickinson, studying in London, refers to Salkeld's works. We know that they knew all about him. He was actually a pretty well respected commentator. So when they wrote the Constitution, they wrote it upon the assumption that it was going to be interpreted in somewhat the same way that you interpret statutes and wills. Now, John Marshall made the famous comment, which is always misunderstood by law professors. We must never forget that is a constitution we are expounding. And what he was saying there is that when we do consider what the makers of the document what intended, we have to consider that they were writing a relatively sparse document for a very long term, as opposed to writing a detailed statute. We have to take that into account. But the lodestar, the end game, is still the same, and that is to understand what this document meant to the makers. Now, you referred to the alternatives to that, often called living constitution theory. The problem here, Sean, is there is no one living constitution theory. There seem to be as many of these theories as there are law professors who want to prove that the Constitution authorizes what they want, or better still, that the Constitution mandates what they want, okay? And so they're always coming up with these different theories to justify it. They've never really settled on one. There are I don't want to get too deeply in the weeds here, but there are all of these different variations. And under those circumstances, the natural question is, why don't we follow the same theory that the same way of interpreting a document we've been following from all other years all other documents for 500 years, and that we applied to the Constitution for 150 years and still apply in many cases.
Yeah, and if we don't, then it leads to
It leads to loss of self-governance.
because
Really.
people at the whim of whoever makes those decisions swings it over in
Whoever-
whatever direction.
There are two things that go on. Number one, if the change agent is the Supreme Court, a majority of 9 lifetime lawyers, they're lawyers, right? They have their own strengths, but there's a heck of a lot they don't know. They're not sociologists, they're not economists, they're not political scientists, they're not construction engineers or any other kinds of engineers. They're lawyers with the strengths and limitations of legal education. And in many cases, and I would venture to say 2 cases on the court right now, they're lawyers of very limited experience who have never done much outside of Washington, D.C. That's a horrible group to make decisions for the whole country. It's almost as bad as monarchy. The second possibility would be for the president to make the change. So the president makes the change in the Constitution. He's not bound by the Constitution. We have a word for someone who does that. It's called monarch or dictator, right? If the president can make up the constitutional rules as he goes along, and by the way, several presidents, including the current one, have dangerously done that, then it doesn't look like a Republican magistracy at all. It looks like it doesn't even look like a limited monarchy. It looks like an absolute monarchy. Or maybe the change agent is the Congress, right? The Constitution was designed to structure and to limit Congress as well as grant powers. Well, if they could rewrite the Constitution, then we have no Constitution. We've just got a system like Britain where if the legislature is determined enough, it can do anything it wants. And that's obviously inconsistent with liberty and our way of life. So those are all those reasons. There's one other possibility, and that is you could have law professors change the Constitution. And as a former law professor, I can tell you that a lot of them have tried. That's the worst of all worlds. They're unelected and accountable to nobody.
We have Rob in the group trying to change the Constitution. I can just see that. But the way we do change our Constitution, the way that the framers came up with was simply amending it. Now, we haven't had an amendment in a while. It seems that people are scared. We're not going to go too deep into this. We already have a show on amending this. People are a little afraid to go into an Article 5. Again, if you want to know more about this, go to the Article 5 Center at the Independence Institute site. Are we gonna amend this again, Rob? It's been a while. It seems like people are a little reticent.
It has been. The last amendment was the 27th Amendment, adopted in 1992. That's what 28 years ago. And that was proposed by Congress, but it was proposed as part of the original Bill of Rights. So we didn't go through the entire amendment process. The last time we went through the entire amendment process was the 26th Amendment in 1970. So that's 50 years ago.
And when you say the entire amendment process, what are you talking about?
Well, I mean, a proposal either by Congress or by a convention, and then ratification by 3/4 of the states. We haven't gone through that process as a unified whole somewhere around the same time for 50 years. And I think,
I'm confused before you go on. The last amendment then we did, it had to have gotten the right vote. How was that done? The last one, you said it's not gone through the full.
The last one in 92, which was the 27th Amendment, was proposed by Congress, but it was proposed in 1789 as part of the Bill of Rights.
Right. Correct.
It was not ratified at that time.
Right.
It was then picked up and ratified in 1991, 92.
But it still had to get all the different pieces together in order to become amendment, right?
Correct. But the entire process didn't happen around 1992. The first half of it happened 200 years before, right?
Right, I got it. So it's been over
the last
about
time,
50. Okay, go ahead. Yeah.
The last time we had all of the entire process more or less at the same time was 50 years ago.
And we're so divided, it's hard to imagine how we're going to get our wits around amending it again. And I guess that, you think that, but if we get to a point where we really see that need, we might get to that threshold.
We are divided about a lot of things, but there's some things that we're not divided on. Overwhelming supermajorities, for example, want term limits. Very strong supermajorities want a balanced budget amendment. Those have not been proposed because they would limit Congress. Congress is not going to propose them. And a convention hasn't met because, as you know, all kinds of scare stories have been told to people about what would happen if a convention happened. There are many constitutional scholars today, and I guess I'm one of them, who think that the process of amending the Constitution is now a little bit too difficult. It certainly should be difficult, right? It certainly should be hard to amend the Constitution. It certainly should require a supermajority. But the
What
way
should be
numbers
changed?
work.
Yeah, go
Sorry.
ahead. But also, as part of
Yeah.
your answer, what should be changed? Go ahead.
The way numbers work, uh, there's a requirement of 2/3 of each houses of Congress to propose, a requirement of 2/3 of the states to call a convention, and a requirement of 3/4 of states to ratify. Now, when those fractions were put into effect, we had only 13 states. We expected 2 more. We expected there would be 15 or 16 real quick. We know statistically, though, it's very much harder to get 2/3 of 50 states than it is, say, to get 2/3 of 16 states or any number. It's also harder to get 2/3 of 100 senators and 435 representatives than it is to get, say, 2/3 of a House of 50 or so. And then on the ratification end, it's particularly hard to get 3/4 of the states, particularly if it's the state legislatures, because to be ratified by a particular state, you got to pass both houses. So there has been, actually dating back to the Civil War, there has been a lot of thought that because of the number of states we have and the larger size of Congress, that maybe we ought to reduce those fractions somewhat. Not enough to be insecure of our rights, but maybe it should be sufficient if half the states petition for a convention, or if 60% of Congress proposes an amendment, or if, and maybe ratification should be sufficient if, let's say, 2/3 of the states instead of 3/4 approve it. There's a growing consensus, and this cuts across the political spectrum, that the amendment process has become a little bit too hard.
Yeah, that makes sense. And of course, we could amend so we'd have to first reach the thresholds we need now to amend the Constitution to have lower
Yeah,
thresholds.
it would be hard. It would be very hard.
It's going to be difficult. All right, let's swing back to Amy Coney Barrett in this situation we're in now. She is I don't know. I haven't done my research, but the last president that's put 3 justices on the Supreme Court. Do you have that in your back pocket?
No, I don't. I don't
Yeah,
recall
I
who the
don't
last
know if
one was.
and I think there was someone, Theodore Roosevelt. There's someone I remember reading.
Well, Franklin Roosevelt essentially appointed the entire court, because Franklin Roosevelt, you recall, served over 3 terms.
Yeah.
He, quote, packed the court the old-fashioned way, which was he basically put a bunch of liberal politicians on the court rather than traditional jurists, and they gave him the results he liked.
Yeah, it's one way to do it. So we have Amy, Judge Barrett is also an originalist. That it's came up a lot in her hearings that she believes in following the wording in exactly the way the intent was for the Constitution. And the other thing I found interesting, I wanted to ask you about, is there was a lot of concern about overthrowing Roe versus v. Wade. And she brought up, and this is what I don't fully understand, and this is addressed to Professor Natelson here. What I didn't fully understand was the power of the precedent in the Supreme Court, because she was kind of like, you don't really overturn the precedent of the Supreme Court. I've never fully understand that because I think the Supreme Court can make mistakes and we need to do that, but
Yes.
I'm not even sure if that's true. So can you walk us through a little bit of that, what they were talking about?
This is a difficult area, Sean. The um, common law courts operate by precedent. There's a principle called Starry decisis, which is vulgarized Latin for to stand by the decisions. Um, a common law court operates in absence of a statute and an absence of a constitution. The decision of the framers was not to have a common law constitution, but to have a written constitution. So you have these judges, they're mostly trained as common law judges.
Mm.
And then you put a constitution in front of them, and their question becomes, well, if it's a common law, we're supposed to follow precedent. Does precedent mean anything in constitutional cases? So you have different judges giving different answers. Judge Breyer, for example, really adjudicates, this is my opinion, really adjudicates constitutional cases as if he were a common law judge. Justice Thomas takes the position that, yeah, if a precedent is arguable, maybe it was decided right or wrong, you can let it stand, because why upset things needlessly? But if the precedent is clearly wrong, you need to overturn it. Okay. And so you have kind of a spectrum ranging from judges who believe that, in theory anyway, that precedent is almost sacrosanct, to judges who believe that precedent is worth something, but in the case of an error, not too much. The problem is compounded by the fact that the staunchest defenders of Roe versus Wade, for example, as precedent, seem to have no qualms about overturning other precedents. So, so for example, there was a decision that the Supreme Court issued, which held that it was not a violation of the Constitution for the states to punish homosexual sodomy, right? And be clear here, I'm not defending statutes that criminalize homosexual sodomy, but the court said, and there's a long history in Western civilization of punishing homosexual sodomy. That was not something that was written into the Constitution. So if a state wants to do it, we think it's a stupid law, but they can do it. Just a few years later, the liberal wing of the court overturned that, led by Justice Kennedy, and said homosexual sodomy is unconstitutional. And the same people who love Roe versus Wade as a precedent applauded with the overturning of the sodomy precedent. Those people similarly applauded when the court managed to upend 6,000 years of recorded history and decide that the Constitution now mandated that the states recognize same-sex marriage. And again, I'm not making a statement whether same-sex marriage is good or bad. It's just it was so well entrenched in our system, it's hard to argue the Constitution requires it. So, so part of much of the discussion of precedent is self-serving. It's people who I like my precedents, I don't like your precedents. I want to get rid of your precedents and we'll keep mine.
Right.
I personally don't think Roe versus Wade has much precedential value because it is so poorly reasoned. And that's not just my opinion. It's an opinion held even by law professors across the spectrum. It's a very, very poorly reasoned opinion, a lot of confusion. It's been boiled down into a statement that, well, a state can regulate abortion so long as the burden on a woman is not undue, whatever the heck that means. I mean, that's just not a constitutional standard. So I don't personally think Roe versus Wade has much value as precedent.
And not and just for anybody listening, he's not making an opinion on whether or not Roe versus Wade is doing the right thing or not. He's just talking strictly about how the opinion was written and if it's strong or not. I just want to make sure before anybody gets too excited about that. He's talking about the legal.
I'm talking about the legal. And let me give you another example. In 1896, there was a case issued by the Supreme Court called Plessy versus Ferguson. And what it said is that it did not violate the 14th Amendment Equal Protection Clause to have separate accommodations for white and blacks, so long as they were substantially equal. This is called a separate but equal document that came out of the Supreme Court. And we look at that and we say that was horrible today. But on the other hand, in 1896, if you study the history in that era, you could sort of understand, well, not justifying, sort of understand why they reached that decision. By 1954, with 58 years of additional experience, we knew that separate is never equal, that it is impossible for a state to maintain separate but equal. It is truly directed as a badge of inferiority against African Americans. We had all of this history to prove that the schools that were set up for African Americans were poorly funded, inferior in various ways. All the good money, went to the white schools. And so by 1954, the message was real clear. The facts were real clear, so clear that they certainly justified overruling that precedent of Plessy versus Ferguson.
Okay, fair enough. So that's the answer to the question. It isn't set in stone. It's just some points of view are saying, no, we can't ever overturn precedent, and some it's not. So in our system, because we have a written constitution and we're not going off of the common law in that case, it isn't held sacrosanct. Sounds like.
Yes.
Did I get that right?
But understand, that's correct. But understand that there's a huge amount of hypocrisy here with, as I said, people choosing the precedents they like and calling for overturning the precedents they don't.
Sure, but I also get that the justices are trying to follow what previous, it seems like anyway, trying to follow previous decisions unless they need to look at it. It sounds like they like to keep that going. That tradition
Many do most of the time, but it often happens that they don't.
Okay. All right. Well, now that we've gotten off of that murky road, Rob, before we're getting towards the end, before I let you go, I want to talk about what a big issue this is that seems to have fallen a little bit of away. And I can't believe it didn't come up in the debate. Was last night, no, night before, whatever it was. Expanding the Supreme Court. I mean, this is a big deal. The Democrats have said they're going to add more justices. What is the constitutionality? Let's give us some framework around this.
The Constitution authorizes the Congress to fix the number of justices at any number it wishes, so long as the number does not fall below one.
So we could have one person on the Supreme Court.
Yeah, you must have a Chief Justice, right? Okay. You must have a Chief Justice. But beyond that, it's totally up to Congress. Now, it's been many, many years that we've had 9, and Franklin Roosevelt famously failed in his effort to expand the court. Whether Democrats, if they won the presidency and won the Congress, would similarly fail, we don't know. I mean, Roosevelt was really riding high when the court packing plan was proposed. He really thought he could get it through. But he ran into a politician who was even cleverer than he was. He was the Chief Justice of the United States, a man named Charles Emmett Hughes, who had served in politics, had served as a governor, had served as an ambassador, as Secretary of State, was a Republican nominee for president in 1916. He knew his politics better than FDR did. And he was able to defeat FDR's effort. And by the way, this had nothing to do with the switch in 9, that idea that the claim that the change of the Supreme Court was a result of the court packing threat has been actually disproven by scholars. But So Roosevelt, at the height of his power, could not get court packing through. But again, that was because I think of the brilliance of the Chief Justice. And also, Roosevelt lost a lot of Democrats who didn't want to sanction this.
Mm.
Today, I think the Democrats are closer together in view. They're a little bit more militant, and we don't know if a Charles Evans Hughes would arise to oppose it. Chief Justice Roberts doesn't strike me as the man, but so we just don't know. They could pack the court, but we don't know if they'll succeed.
And that would just be basically a statute. The Congress would pass
Yeah.
a statute, it'd go to the president, and he would veto or pass it and
Right.
add a couple more. You'd need to have an odd number, I suppose. So you'd add up to 11 now instead of 9.
You could, although at one time we had 10 justices on the court.
And is
In
that
fact,
what
I believe
Roosevelt,
Hmm?
was he trying to get 11?
He was trying to get 15. His bill said that the president had the right to appoint one justice for every sitting justice over the age of 70, and there were 6 of them. And that was part of the problem. I mean, it was, in some ways, it was kind of a typical FDR deal where he got too clever for his britches, you know.
Didn't we have some goofy stuff come out of the Supreme Court from all those people he put on? I mean, we've had some interesting things come out of there at that point. He put politicians on versus judges, yeah?
Yeah, I think we have talked about this again, Sean. This is a large we have talked about it before.
I know, this is a huge
and it's a large topic.
Yeah.
But he managed to change the composition of the court not too long after his unsuccessful court packing scheme. Chief Justice Hughes retired in 41. A number of other justices retired about that time. And he started appointing basically as politicians with pretty limited judicial experience. Justice Black, for example, Hugo Black, had been a senator from Alabama, an officer of the Ku Klux Klan, and his judicial experience consisted of 2 years on the Alabama local police court. And most of the appointees had even less. And so at that point, the Supreme Court basically took a dive and gave Congress and the president whatever they wanted. And this continued until the Korean War, when they finally reared up against President Truman and struck down his effort to nationalize the steel mills.
You know, based on what you just said, Rob, I think I could be on the Supreme Court if we're going to go back to those kind of standards. Yeah, I'm an American. Yeah. I'm over 18 or whatever. I'm good. So, yeah. Okay. You know, I keep saying I have a last question, but I have a last question, Rob. So, you know, we haven't spoken since the pandemic. I'm just curious, your thoughts constitutionally. Could the president, whether it was Trump or anyone else, have done more from his position across the states, or was he more constitutionally correct to let the states run what they needed to run? Not necessarily what's right or wrong. I'm just kind of looking at this point. What constitutionally was correct?
The latter. His constitutional powers in a health emergency are pretty limited. I mean, he certainly can close the Chinese border, right? And there are a few other things he can do. But as Democratic governors like Mario Cuomo have reminded him several times, the primary job of dealing with health crises is on the states. That's a quintessential, a very characteristic state power. John Marshall said that among the vast reservoir of powers the federal government doesn't have that are reserved to the states are, quote, health laws of every description. And so that really is their function. When I saw the final presidential debate, much of that debate greatly frustrated me. And one of the frustrations was the assumption that the president was the chief health officer of the United States. I suppose if I were in President Trump's position, I might be tempted to remind the audience of the constitutional restrictions on the president. But in a debate situation, that's risky to do. That looks like you're just blaming other people for the problem. So he sort of had to answer as best he could, but with limited exceptions. To be blunt, it's not his issue. It's the issue of the governors and the local health officers.
It's interesting. I think we're losing knowledge of the Constitution. We've talked about this. This is nothing new to you.
Yeah.
We're losing knowledge of the Constitution, really what the powers of the states should be, the federal powers. Too many people in this pandemic have been screaming that we need the centralized government to come in and run this whole thing, kind of like what we're seeing in these other countries, South Korea and some of these other places that have a much, much different and more restrictive government system than we have. It's just a little disappointing when I see that they don't understand that. Yeah, I get that maybe, I get maybe in this case, it's centralized, it might have helped, but it's not built into our system. And our system comes with its benefits and its drawbacks. And I'm not saying it was one way or the other, but people don't seem to even understand that it would be stepping on states' rights to do that.
Well, it goes beyond constitutional. It would be to adopt a centralized approach to COVID would be monumentally stupid. Continental decisions result in continental mistakes. One role of the states, as I believe it was Justice Brandeis pointed out, is that they're laboratories of democracy, that states learn from different states. Also within states, there are counties that are dramatically different from each other. I live in Colorado. We have counties in Colorado that never had a COVID case. There are significant differences between the level of COVID in New York, Colorado, and Montana. Mm-hmm. And the notion that you can have a cookie cutter solution that cuts across the country is an exceptionally stupid one. It's not only unconstitutional, it's really just, as a matter of policy, stupid. It's from people who don't know anything about what makes life work outside maybe their own little world.
It's always refreshing to talk to you, Rob.
Thank you.
I like that you tell us how you feel.
I got a little ragged there.
I like how you tell us how you feel. We haven't gotten to talk during the pandemic. You've been off, and now you're back. So now I can grab you, hopefully, and get you back again, and we'll talk. We have the election in a couple of weeks, so after that, we'll see what happened, and then we'll see what the next topic that comes up. Anything you want to do before you part ways here? Anything else you want to say?
Sean, don't you think that's enough?
Man, I think that last statement was just terrific. I really appreciate that, Rob. I missed having you on the show.
Well, anytime. Just give me a call.
Good. We'll do it again. Thank you, sir.
Thank you.
So it was Professor Rob Natelson. Always like having him on the show. He pretty much sticks. I've not found him to be partisan. He sticks to what he knows, very deeply knows about the Constitution. And so anyway, there you go on that. Don't write me a whole bunch of emails. You're upset about any of those kind of edgy things he talked about. He's just literally talking about the actual decisions by the Supreme Court. Okay, so we're almost at the election. Go out and vote. That's what you should do. This is a very, very rare, really in the course of history of life, of humanity, to be able to go and vote for someone who is to be your leader. And then we turn that over and we have potentially somebody new when offices change. So it's a rare thing. Go out and vote. Too many people do not vote. Half the people or more sometimes don't vote in these national elections, and it's just a shame. So take up your right and your actual responsibility, because the country only runs with you in charge of it. We are in charge of the Constitution. We're in charge of our government. The government is not in charge of us. We are ultimately in charge of this government. So your way of influencing that directly based on our Constitution is to go out and cast your ballot. Though at times it seems it's a waste of time. I get it. But go out and do it. It is, they call it your civic duty, but it's actually a responsibility. You're part of the board of directors of this country, and you need to throw out your vote. Stay well out there. Take care of each other. We'll talk to you the next time. Bye-bye.